Today, Jay, I want to talk to you and the people who regularly watch our videos about this issue that we're seeing a lot, which deals with people who are getting denied at this 24-month or 12-month mental nervous limitation, when in fact they also have some kind of physical condition that's going on as well, but the disability carrier is saying, well, we think you're disabled mentally. We know you're telling us you have some kind of other physical issue, but we just don't think it's disabling, therefore we're going to deny your benefits. And I'm seeing this at least 5, 10, or 15 times a week on these types of cases. So from your experience of handling tons and tons of disability claims, when do you most common see a disability carrier is looking to limit a claim to the 12 or 24-month limitation?
Right, so typically what you would see is at the 24-month mental nervous limitation, there's language typically in the definition that speaks to the disability being caused or contributed to by other sources. And when the carrier looks at the claim, they're going to look to see that there's a physical aspect to the individual's disabling condition and what might be restricting or causing limitations on their ability to perform their job. And what the carrier is looking at is at the 24-month change in definition, the 24-month limitation, when you have both a mental and a physical disability, is whether the physical disability by itself is going to be disabling.
Okay, and so there's this language which I think is the key, and let's try to break it down because we're lawyers and we see it all the time, and there's lots of case law, and we'll use 2 cases in a minute to talk about as an example. But I think the key language is the cause or contributed by.
Right.
And where does that come into play? So obviously they're talking about the mental condition. Did that cause or contribute to your disability? But what if, and let's use one of the other cases you had as an example, where someone has lupus, but they also have depression.
Right.
Can that person continue on disability when they're diagnosed with both?
Right. And oftentimes what you see when an individual file a claim, they'll tell the insurance carrier all of the different conditions that they have, whether they're physical or mental, emotional conditions. And the carrier will look at the total complex of conditions, and they'll make a determination on disability. Well, at the 24-month change, when you see that cause or contributed to language, what they need to see is that the disability by itself, the physical disability standing alone, without being caused or contributed to by the psychiatric condition, is going to continue to render them disabled. Oftentimes you have individuals who the 2 conditions, the psychiatric and the physical condition combined, render them totally disabled, but individually may not. And during the first 24 months, as long as the total symptom complex renders them unable to do their job, they'll pay the total disability benefit. But once you get to that limitation period deadline of 24 months for the emotional or the mental side, they're going to need to see that the physical can stand on its own and continue to be a disabling condition.
Okay, so it's a very fine line, and I've said before in tons of videos that if you have a physical condition which keeps you from working, I would say more than 75% of the people we represent also have some kind of psychiatric element. I mean, it's depressing, it's anxiety driven to not be able to do what you used to do.
Right.
So, but you're saying the way the case law is, and obviously the way that we like to argue the case law, is that if your physical on its own is so severe, then you should be able to get past that limitation, regardless of the fact that you have a diagnosis of depression, anxiety, bipolar, or whatever else it may be.
Exactly. And the key to that determination is going to be that you see your physician and that you document those physical disabling conditions. Really what it's going to come down to is most carriers will not find you disabled based on a diagnosis. Simply because, in that case that you pointed out, simply because the woman was diagnosed with lupus, a diagnosis does not equal disability. The limitations and restrictions that flow from that lupus are what's going to render them disabled. So in basic terms, how that condition, that diagnosis affects you on a day-to-day basis is what's really going to carry the day for the insurance carrier.
Right, and you brought up a great point, because what a lot of people have to realize is it's very hard after the fact when you were getting paid for depression or anxiety or whatever mental condition it may have been, and then you go, oh, by the way, I just got diagnosed with fibromyalgia or lupus, or I have a herniation in my neck or back. Well, that's going to make it very difficult if you didn't present that before the limitation period was. That you
Right.
didn't document it with your doctor, and your doctor didn't say, okay, I think you're restricted from the physical.
Right.
Even if it's the physical as well as the mental, but the physical on its own, again, has to be limiting.
Right, and I think one of the things that really needs to be stressed in this situation is that's why attorneys like us should be involved at the earliest possible moment in the process, because if an insured files a claim and they have conditions that they identify for the carrier that are both mental and physical, and they get paid, they may not be thinking down the road. They're saying, well, I'm receiving my full benefit. They're not thinking down the road, and the carrier is going to notify them maybe 3 months, maybe 6 months beforehand, and tell them that a change of definition is coming, and the individual who's dealing with these disabling conditions is now left to kind of scurry around to try and put something together. Whereas if they were, if attorneys like us were involved at the get-go, we know these types of issues come up down the road. We prepare from them from the onset of the claim, as opposed to dealing with them at the last minute or receiving a call at the last minute.
Right, and I think you're being generous with the 3 to 6 month notice, because often I
Yeah.
see it's 12 months. Oh, by the way, your next check isn't coming. We find that you're disabled by the mental nervous limitation. We're not going to pay you anymore.
Right.
So, all right, so if you're in this situation, or quite frankly having any issues with your long-term disability insurance carrier, feel free to call any of our lawyers. We're happy to provide you with a free consultation, and we will let you know right away whether or not we can assist you.